Hi, I'm Carl Pearson, a New York attorney, and I'm making this video as the fifth one in a 12-video series which should be viewed in sequence from A to L. And what this is about is I'm warning you that you must use an attorney. The title of this is Get an Attorney or Get Evicted, and it's a very serious thing, so listen please. In any foreclosure-related problem, you should get an attorney or risk getting evicted. This is not a self-serving statement by me, even though I'm an attorney. Whether you retain my services or the services of another attorney, you are heading for a disaster if you try to handle most foreclosure problems by yourself without an experienced, competent foreclosure defense attorney. This warning also applies as to any loan modification applications you may have been making. The preparation of loan modification applications may have substantial legal issues needing an attorney, and in any event, loan modification applications are an integral part of foreclosure defense litigation because they often lead to the resolution of the lawsuit, and that is why you get a loan modification, because you have a lawsuit. They should be prepared and submitted under the attorney's supervision and sent to opposing counsel as part of the litigation effort in opposing a foreclosure or a threatened foreclosure. If you don't use an experienced foreclosure defense attorney in fighting foreclosure, you probably, from a statistical standpoint, will not obtain your desired loan modification agreement without litigation. And if you litigate yourself without an attorney, your litigation will probably not be successful from a statistical standpoint once again. Now let me explain why you need a lawyer who is an experienced, competent lawyer in defending against foreclosures. There are a variety of reasons. Number one, the first is that foreclosure litigation conducted by a competent attorney could be quite costly to the bank and servicer if the lawsuit is not settled. They may have to pay the legal fees of outside counsel in the range of $20,000 to $100,000 or more if the litigation is not settled. It's a lot of money for the bank. Two, if the value of the homeowner's property is low, the bank's litigation costs could wipe out the value of the bank's interest in the property. In other words, if the litigation costs for the bank add up to $60,000 and the property is worth only $50,000 at auction, the bank will lose its entire investment unless it settles the foreclosure litigation. And that assumes, of course, that the homeowner is judgment-proof as to any deficiency judgment. Three, when you are in litigation and the bank has outside counsel, your loan modification application, which you probably should be making once again, even if you have done so a dozen times before, is going to be reviewed first by the bank's outside attorney, and then that attorney sends it directly to the loss mitigation department of the bank for its analysis and preparation, hopefully, of a loan modification agreement proposal for you. Four, this is a more probable route for a successful application than if the application is sent once again to one of thousands of nameless, often foreign representatives of the bank with whom you have been dealing unsuccessfully over the past years, whose main duty, it seems, is to find fault and keep asking you for more or updated documents until you give up in exasperation and the bank wins because they say that you apparently are no longer interested. Five, it appears that banks have been receiving $1,000 or so per application from a government program, which has encouraged the banks to have you resubmit applications instead of trying to complete your first application. When your application is handled by two law firms, one representing you and the other representing the bank or the servicer, you will not see this happening. Six, the bank's attorney has a direct line of communication to the officer of the bank in charge of granting you or denying a loan modification application by you, with almost no chance that the application will be ignored or forgotten about. Your attorney and its loan modification paralegal will be anxious to help you submit your application on a timely basis as desired by the bank or its servicer. Seven, while in litigation, you have an opportunity to obtain discovery of the servicer and bank including the information you need to determine who is the holder of the note, the chain of title, gaps in the chain of title, robo-signing, and other matters that you would otherwise not be able to get. 8. Because you are in a position through litigation to obtain evidence that the bank otherwise would not give to you. You are more apt to have the bank grant you a loan modification in order to avoid having to respond to these threatening and costly discovery requests that you will be giving the bank. 9. One of the most important considerations, I believe, is that if the foreclosure litigation is not settled, it could result in a court decision costing the bank billions of dollars in other cases. To avoid decisions like the Ibanez decision in Massachusetts, the bank or servicer is often more likely to settle with a reasonable loan modification agreement than to litigate your case to the very end. 10. Litigation is time-consuming for the bank as well, and nobody likes litigation if it is something to try to resolve. The judge wants to resolve each case. The parties especially want to resolve cases from a satisfactory standpoint if possible. And believe it or not, the attorneys on both sides want to resolve the litigation generally. It is entirely possible that the bank's attorneys are selected by their ability to reduce litigation rather than to keep the litigation open. So with all of these benefits that are potentially there from litigation, the homeowner will lose most of the benefits if the homeowner tries to litigate alone, called pro se or in pro per, if the homeowner's attorney doesn't represent his or her client properly. So you have the situation where if you try to do it alone, or if you try to do it with an attorney who doesn't know what he's doing, then the bank is not going to be threatened by the litigation. The bank's attorneys can tell whether or not the homeowner's attorney constitutes a threat to the bank or not. If you lose your foreclosure litigation, you are probably going to lose your home and face eviction at some point. Using a competent foreclosure defense attorney with experienced loan mod paralegal services gives you a substantially better opportunity to avoid losing your home and getting evicted. Of course, there are no guarantees. Litigation results cannot be assured, and that's so even for the bank. In summary, a homeowner needs a competent, experienced foreclosure defense attorney, and you will find that this is somewhat difficult to do for most homeowners. It's difficult to find such a person. It's similar to the difficulties I would have in trying to determine if a specific doctor is competent in his or her field. I deal with this problem by offering my services to assist local lawyers throughout the country, and in my final 12th video in this series I explain how you can find a local lawyer. I'm finished now with Get an Attorney or Get Evicted, and you should go on to my next video, 108F, called Loan Modification Agreements. Any questions, please give me a call at 212-307-4444. Thank you.